While stopped for a traffic violation eventually leading to an arrest on a weapons charge, can police seize a person's cell phone, which then leads to additional criminal charges? This was the question in the case of smartphones and searches incident to arrest. In this case, the United States Supreme Court was confronted with the arrest of Riley, who had been stopped on a traffic violation. While searching Riley incident to the arrest, the officer seized a cell phone from his pants pocket. The officer accessed information on the phone and noted the repeated use of a slang term associated with a street gang. At the police station 2 hours later, a detective specializing in gangs checked the digital contents of the smartphone. Photographs and videos were found from the contents on the phone, and this information linked Riley to a shooting, which had occurred a few weeks earlier. Riley's charges were enhanced due to his gang membership, and his attorney moved to have what was discovered as a result of seizing the cell phone suppressed. How would you decide this case? Does the Fourth Amendment to the Constitution permit the seizure of a person's cell phone in a search incident to an arrest? We'll be back in a minute to answer that question. Does the law permit the police to seize a person's cell phone in a search incident to an arrest? No, said the United States Supreme Court. The police generally may not, without a warrant, search digital information on a cell phone seized from an individual who has been arrested. Riley's case required the court to decide how the search incident to arrest doctrine applies to modern cell phones and balance the privacy interests of citizens under the Fourth Amendment, which provides the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause. Previous case holdings by the court required that a search incident to an arrest be limited to the area within the arrestee's immediate control, where it is justified by the interests in officer safety and preventing evidence destruction. So the court held that officers may examine the phone's physical aspects to ensure it will not be used as a weapon, but the data on the phone can endanger no one, and the phone cannot be seized or taken for examination without a warrant. Cell phones can store millions of pages of text, thousands of pictures, and hundreds of videos. Indeed, a cell phone search would typically expose to the government far more than the most exhaustive search of a person's home. The court noted that while its decision would have some impact on the ability of law enforcement to combat crime, the holding was not that information on a cell phone was immune from search. The holding is that a warrant is generally required before a search. Remember, it's a matter of law.